Good morning. This is the meeting of the Discipline Subcommittee of the California Paraprofessional Program Working Group. I'd like to start by taking roll. Bashan?
Present.
Falmouth?
Here.
Kirkmeyer?
Here.
Spiro?
Here.
Great. So it looks like everyone is here. There are some members of the public who have joined us. If there's anyone who's interested in making public comment, you can do that now. Please raise your hand using that function in the Zoom meeting. Doesn't look like there's anyone who wants to make public comment. So I'd like to go ahead and start. We have a number of guests who have been invited to talk about the unauthorized practice of law and the potential impact of a new licensee class in potential implications for the unauthorized practice of law. We have Ryan Jorben from the Los Angeles District Attorney's Office. We have Gus Hernandez and Steve Moad from the State Bar's Office of Chief Trial Counsel. I'd like to ask each of you to introduce yourselves, and then we can turn to more of a detailed discussion and questions and answers. So do you want to start, Ryan?
Okay. Good morning, everyone. My name is Ryan Jorben. I'm a Deputy District Attorney with Los Angeles County. I'm part of our Consumer Protection Division, and I am an attorney in a small subunit of that division called the Notario Fraud Unit. And I focus on prosecutions of unlicensed and unlawful practices of law that affect our undocumented and immigrant communities specifically, but any general unlicensed practice of law cases I also review for our office. I'm here to talk about what we are seeing at the prosecutorial level for the discipline and the issues there. I also handle any fraud that is dealt for immigrationists generally. So for immigration attorneys and ICAs who are, although licensed correctly, are committing fraud against victims. So thank you for having me.
Maybe Steve and then Gus, you can introduce yourselves.
My name is Steve Moad. I'm with the Office of Chief Trial Counsel, and I work with Gus, who supervises our NAUPL team. Gus?
Good morning. I'm Gus Hernandez. I am the supervising attorney for the non-attorney unauthorized practice of law unit. That concerns people who are not attorneys, who have not been licensed, as well as former attorneys, those who have resigned or been disbarred. If they are suspended or still active members, of course, that's a whole nother department that handles that part of UPL.
And I think maybe it makes sense to start with the people from the Office of Chief Trial Counsel, because that's where these complaints come to our attention and you sort of work on them and then refer people to the DA's office. So I think just in terms of logical progression, we can start with maybe Gus.
Okay, sure. So I'm here to share with you our investigative and enforcement processes that we employ when we're looking into allegations of the unauthorized practice of law by non-attorneys or by former attorneys. And I'll start out by explaining the remedies that are available to the State Bar and how we seek to have those enforced. And then we'll get into more particular details about how we actually investigate the case. So perhaps the most important tool that we have available to us in our arsenal is the assumption of jurisdiction over the practice of a non-attorney. That is something that we obtain through Superior Court. That is not a State Bar court matter. The Business and Professions Code, section 6126.3 and 6180 and 90 allow us to seek that the court issue an order to assume jurisdiction over such a practice, an unlawful practice. And then they essentially appoint us, the state bar, to execute that order by going into that office, seizing the files, seizing bank accounts if we know of them. Sometimes these are just cash businesses, so there's no bank accounts. We redirect mail and phone calls to the state bar to basically ensure we're making our best effort to shut down this particular office. So that's something that we have available to us. The evidence that we need for that is not particularly overwhelming. All we need to show is probable cause that the non-attorney or former attorney has engaged in the unauthorized practice of law, and show probable cause that the interest of an individual or an entity will be prejudiced if this hearing or this proceeding is not maintained. We usually attach declarations from the complaining witnesses, exhibits such as a particular document that may point or establish the UPL, evidence of payments, and internal records to show the court or to establish to the court that this particular person is not someone who's licensed by the State Bar of California to practice law. And as simple as that seems, we do encounter some problems, particularly in immigration matters. For example, the witnesses are gone by the time we need their declarations to seek an assumption of jurisdiction matter. The respondents may be gone. Maybe they used a fake name or a fake address, and we can't find them. So we do have our difficulties with those assumptions. But when we do, I don't remember actually ever losing one of them. So when we have all of the information, all the evidence, we actually, the court is very willing to issue that order and help us with that. Another thing we have available to us is an injunctive relief pursuant to Business and Professions Code 6030. They will issue an injunction against these non-attorneys and former attorneys. This is something that we typically incorporate into our pleadings for an assumption of jurisdiction. It doesn't require any additional evidence really, and the court has always issued those injunctions when we requested them. Another thing that we do is we issue cease and desist notices or letters. That is when an assumption is not warranted. We will issue the cease and desist letter to try to get these people to stop engaging in practices that are essentially UPL. And when we do this is when we find that there is no evidence of an ongoing business. In other words, the threat to the public may not be there because they're not operating a thriving business or the business has shut down. This is an isolated incident where it's not likely to recur. So we're hopeful that the issuance of a cease and desist letter is something that will prevent the UPL by these people. And it does stop some people. Some people, when we bring it to their attention, they say, I didn't know that, for example, if they're an LDA or an immigration consultant, and we bring it to their attention, they say, I didn't know I was exceeding the scope of what I was permitted to do, and they thank us, whatever. The State Bar also posts or publishes the issuance of a cease and desist notice on our website. And that includes the name of the individual, as well as all aliases and DBAs. And that serves a public protection service, because those who want to protect themselves, those members of the community, will go to that website and see, okay, well, this person has a history or will cross the line or whatever, and will hurt their business even if they're still trying to engage in UPL out there. So cease and desist is something that we do a lot of. We issue a lot of those. And we also do law enforcement referrals. UPL is a crime. So we send out law enforcement referrals, and Ryan can attest, she's a recipient of a large bulk of our business. We send them as soon as we forward a case to investigation. We don't do it at the conclusion of the investigation. And the reason we do that, and we recognize that sometimes a lot of times the complaint or the investigation is not complete, but we want to prevent any issues with statute of limitations. So we send those to law enforcement as soon as we open an investigation. And throughout the investigation, we will supplement, if we receive any documents, we will supplement the DA or the attorney's office with that information. And certainly at the conclusion, we will also do that. with respect to my team, the NAUPL team, it is a vertical team. We're self-contained. We do the intake, the investigation, and the superior court actions if necessary. So before we forward a case to investigations, an attorney will be assigned to review the matter in intake to see if the complaint actually alleged sufficient facts constituting UPL. If not, the case is closed. If it does, we forward it to investigation. And at that point, an investigator is actually assigned. The attorney who conducted the initial read remains on the case, but now has an investigator. And the way we conduct our investigations or aim to conduct our investigations is to have the investigator and the attorney meet typically within 5 days of receipt of the file to discuss the case, develop an investigation strategy, determine what information is still necessary, when should it be obtained, and other things to help prioritize the cases. Again, determining first and foremost whether it's an ongoing business, something that requires more of an urgent view and handling. And there's other things that go on throughout the investigation, including the investigation plan that's prepared initially. And typically within 20 days of the investigation being opened, we like to send what we call a TR letter to the respondent, to the non-attorney, I should say, and former attorney. And this letter is essentially a letter that tells the recipient that we have received a UPL complaint against them. We are investigating them. We are asking for their input to address the allegations. We usually request a written response within 10 days of receipt. Many times we get these responses and we evaluate them. A lot of times we don't, so we send a follow-up letter, but we don't waste a lot of time with that. If they don't respond, if we have enough to act on it, do, and if we don't, we have to close it at that point. Sometimes, we don't send these letters to non-attorneys. There are instances, for example, when sending such a letter will alert that non-attorney or former attorney that we are investigating. And what they do then is they close up the shop, they're gone, and now we have nothing that we can do about it. So we don't give notice. And there's also a way that if we are going to pursue an assumption matter against them, we can actually do that without notice of the ex parte. So the first notice they're going to have is when we show up with the court order at their office door, telling them we're shutting them down. So this is a little different than how trials operates against active members. There's a lot more due process and that are applicable that afford them a little more notice or require notice. Let's see. Our investigators also keep in constant contact with law enforcement. We help them with any information that they need to prosecute the case criminally before we do anything such as an assumption or something a little more drastic. We consult with law enforcement also because we do not want to interfere with them if they have an ongoing investigation. We have had instances where law enforcement has actually told us to stand down because they have an investigation pending. So we just hold tight and wait for further instructions, and we will get them later on. So other things that we do in investigations are we contact the complaining witnesses for additional information or documentation. We check Odyssey for closed complaints. Sometimes we'll close a case because we didn't have sufficient evidence, but now that we have another complaint, we could look at that one and revisit it and perhaps reopen it. Again, we look at to see if there's an ongoing business. We look at business licenses, records with the Secretary of State to see who we can find that might be a responsible party or who actually owns the business. We do research to see whether or not this person can be providing the services that they're providing. For example, it might be an out-of-state attorney that's being complained against. Well, we'll look at the other state's jurisdiction records to see if they are licensed to practice and provide the service that they are providing here in California. As the primary example of that is the immigration cases. If licensed in another state, you can practice that here in California. Where sometimes they get in trouble is, you know, they don't limit the representation exclusively to the immigration matter. Sometimes they come in for a DUI and they're going to represent them in the DUI as well as the immigration matter. Well, now they're UPLing with respect to that DUI because they can only provide representation with respect to the immigration matter. So, and we do site visits. Again, that's an important thing to determine if there's an ongoing business. A lot of times the office is gone. Can't necessarily trust Google or Yelp to tell us if it's a closed office. I know I went to court once in Riverside and I decided to stop by an office where Yelp ad said this office is permanently closed. So I just decided to check up on it. It was right down the street from the courthouse, and on the non-attorney giving legal advice to an immigrant. So site visits are important. Pandemic put a little bit of those on hold, but we're still doing those. Let's see. One thing that is important to recognize is that the state bar is not law enforcement. We do not criminally prosecute the non-attorneys or former attorneys. We cannot do undercover work. We can't do surreptitious recordings, execute search warrants, obtain restitution. We are very limited to essentially what I've just described in what we can do to help prevent the UPL by non-attorneys and former attorneys. And and essentially at the conclusion of our investigation, those are our three options that we do. We closed the case if after the full investigation it did not yield evidence of UPL, or we send a cease and desist letter if we think it's an isolated incident not likely to recur, or if we have an ongoing business, we obtain an assumption of jurisdiction order from the Superior Court. And that's pretty much it. Thank you.
Thanks, Gus.
Well, thank you, Gus. That was very helpful. I think that's a perfect segue to Ryan's discussion about what law enforcement can do.
Thank you. I do work with Gus and his team, and they are excellent. And I really appreciate all the cooperation we get from the State Bar. Couple things I wanted to just cover up front before we get started is, first of all, as I said, I'm part of the Notario Fraud Unit, and I have been monitoring the public meetings of this committee and the general working group. And I know that there was some concerns about the term notario being disrespectful or somehow racist because of the, it was brought up by, I think, the civilian member of the working group in the general meeting. Notario is actually a term of art that is used by the immigration support system of the United States. So everyone from CHRLA to the Office of Immigration Reform to every legal aid group and immigrant support group uses that term. In fact, it's so widespread that it is used in the actual language of the statute of the Immigration Consultants Act as something that is not allowed. And it is because the term is used to create a comfort level in Spanish-speaking communities to use people, because notarios in Spanish language communities in South and Latin America provide legal services, are paraprofessionals that are licensed and legal. They are not here, and they are not used, that term is not used by people who are legally providing services here. And it is a term of art that is specifically used to victimize communities where that is the cultural equivalent of an attorney. So I think it's very important for this committee and the working group in general to understand what the language is that we're using, because it's not really appropriate for us to not use that term when it's the term being used by the community that is being victimized by that term. So, I just wanted to clarify that so that if it comes up again somewhere where I'm not speaking, we can clarify that for anyone in the public who is listening into the conversation. The second thing is that I know that there's been some statements and concerns that this focus for both public interest, consumer protection, and prosecution is that we think everybody's going to commit fraud. We really don't. We know that 99.9% of people don't commit fraud. Thank God, because we don't have the people. If they did, if it was higher than that, we get it. Okay. But our concern is always trying to keep the dam from overflowing to the point where we cannot serve the community who is potentially being victimized. And so one of the reasons I'm here is to talk about kind of what we're already seeing. And as someone who's been doing this job for 22 years as a prosecutor and been working on these cases for 3 years, my concern is that once we legalize another group of people to provide services, we need to make sure that that 0.1% of them who are not going to do right by our citizens are somehow, that there's somehow some way to control that and make sure that we are protecting our community from them. So it is not that I think a paraprofessional is more likely to commit fraud than a lawyer. Trust me, I prosecute lawyers. I know what the dangers are. What my concern is making sure that we are aware of what we are doing and that we put in the protections ahead of time so we're not trying to catch up. So Notario Fraud Unit, that's what I am part of. My marching orders from the County Board of Supervisors is to provide support to undocumented and immigrant members of our community who are targeted for fraud as particularly vulnerable victims based on cultural differences, immigration status, economics, education, sophistication, but are particularly vulnerable to certain kinds of fraud, especially what we call affinity fraud, which means members of the cultural community using cultural knowledge to victimize members of their own community. So in the 3 years that we've existed, we've done 11 major felony cases plus other smaller cases. And just in those 11, we've received orders for over $5 million in restitution, and we've helped over 350 victims. So if you're doing the math, that's over 35 named victims in each case. And those are just the ones that are willing to come forward and tell us. Since most of these people are undocumented or are not legal citizens, participation is terrifying, frankly. And one of the charges that I charge a lot is extortion, because we will have these people saying, if you tell anyone, I will call ICE. In addition to those 11 cases, I currently have on my Notario cases alone, because I also handle other types of fraud against immigrant communities, 11 investigations covering over 500 victims and unknown millions of dollars. I mean, if you figure everybody in that usually pays between $2,000 and $10,000, you can see the size of the problem. And in those 11 investigations, there are multiple licensed attorneys who are and licensed immigrant consultants under the code that are committing these frauds against our victims. Okay, so this is not just an unlicensed practice of law, it's both. And so you need to, it's important, I think, when we're talking about discipline or regulation, to understand that the problem already exists. All we're going to do is explain to the community that these paraprofessionals can now provide these comments, and that 0.1% or whatever it is of those people are also going to have these disciplinary issues that we already see in our licensed and unlicensed professionals. I do receive every unlicensed practice or unlawful practice of law complaint that makes it to the investigation stage with State Bar. When I started, we got all of them. The moment they made a complaint, we got all of them. So we were getting 400 to 500 a year. Both the state bar and I decided that was way too much. And so now I only get the ones they deem sufficient for investigation. I counted in 2019, I got 116 complaints that were sufficient for investigation, just of unlicensed and unlawful complaints. So that does not include any licensed ICA, any licensed immigration consultant. ICA is an immigration consultant, any licensed ICA, or any professional attorney. Those are other complaints. So, you know, add to that level. Because there's really two groups of people here that I'm concerned about. The one is the fact that when we tell people, hey, you can get legal assistance from paraprofessionals, how, you know, educating the community on how to find a safe paraprofessional to go to, just the same way as we do with lawyers, right? There's crooked lawyers, there's going to be crooked paraprofessionals, there's crooked everybody, okay? So that's the first part. The other part is maintaining, is understanding that once we say paraprofessionals are safe and licensed, and I have no, you know, I have no opinion about whether or not that's the right thing to do. Once I'm saying it happens, it is going to be out there in the community that you can hire a paraprofessional. And so we will see an uptick in people pretending to be licensed and providing legal services. We know we will, just like anytime we, just like with COVID, fraud for COVID, you know, vaccines goes up, because once there's a vaccine out there, somebody out there is going to start selling fake vaccines. Okay, that's why criminals stay in business. That's why I have job security. So, so what we need to look at then is what it requires, because one of the things that I've heard discussed is, well, if our discipline system doesn't work, then the DA handles it, and we don't need to deal with that. But I'm begging you to deal with that. And I'm begging you to deal with that because for each case that I get, for those 116 cases, if I was going to prosecute them, and I can't, there's just not enough resources in the world to prosecute them. But let's say half of them are valid, or a third of them are valid. I mean, Gus could probably tell us what percentage of those actually come to some fruition, but let's say it's 20%. All right, so 25 cases. So that adds 25 cases to my caseload already. I already have 11 investigations, right? That requires each one of them have a law enforcement officer investigate them, at least one, because the state bar does an initial investigation, but they are not law enforcement. They are not able to testify in a criminal case in the same way a law enforcement officer does. And they don't have the same powers that law enforcement does. So every one of those will need a law enforcement officer. It requires a DA, of course. My notario fraud unit that handles this is me and half another lawyer at full staff, which we are hoping to get, but with funding, both with COVID and the shifting of money away from law enforcement and into social services, I don't know if we will come up to our full staff of 3 full-time lawyers, but that's still just 3 full-time lawyers. And then law enforcement. So the state bar has no jurisdiction over this, nor should they, frankly. But that lack of jurisdiction means they can't help the victims except to provide them with their records if they seize their files, which they do and is great. But it still leaves that victim out in the cold without their money and without legal assistance. The other issue we have is UPL is a misdemeanor. So anytime anyone commits an unlicensed practice of law, they are not an attorney, they're only looking at a misdemeanor. Well, why does that matter? Well, I have a person on my desk right now who has been pretending to be a lawyer since the 90s. We've prosecuted him 6 times for unlicensed practice of law. He has stolen hundreds of thousands of dollars from victims. We've had victims placed in custody because of him. We've had them deported because of him. And the most I can do is file a misdemeanor complaint on him. And then, of course, like everyone, the resources are limited. So the question becomes, what are my recommendations as you go forward for this criminal aspect of discipline? The Immigration Consultants Act is has its issues, don't get me wrong. But one of the things that it did is it did say that subsequent convictions, we call them priors, okay? So this gentleman I have who is now on his 15th unlicensed practice of law complaint. If you have one filed, that's a misdemeanor. If you have more than one filed, it should give the prosecution the right to file a felony. Why? Because that gets us off the streets. We can protect better. It's more of a cost. A misdemeanor is a very small cost to someone who has to take, maybe a month or two off to go to jail, if that long. Especially these days, misdemeanors don't stay in custody that long. There's very little stick without a priorable sentence. So my recommendation, and I can send this to anyone who wants it, is that we look at 6126, which is the penal code section for the unlicensed practice of law. Wait, did I see? And that includes language that says, upon a second or subsequent conviction, I'm sorry, that the person can go to, let me start again, that we should look at the ICA, which is 22445. I got my sections mixed up, I apologize, which says that a second or subsequent violation of any provision of the chapter besides things like font size for warnings is punishable by state prison. The UPL right now says you can go to state prison if you're an attorney who was disbarred and you do it more than once. But if you are not a lawyer and you keep doing it over and over again, you're never going to get anything more than a misdemeanor. So Linda, when she and I chatted, she came up with the very simple fix, really, that when this legislation is being formalized for these new paraprofessionals, a fix to the UPL law, to 6126, adding the language that's already there for lawyers, for for non-lawyers, is incredibly important to protecting the community. And if you look at 6126 subsection B, the language is already there. That's what we call a wobbler. It means that they can be sentenced for either a misdemeanor or a felony. We just need to modify 6126A to include that language, to get rid of the second conviction and do that language. And again, I'm happy to provide that. I didn't want to give you a bunch of text. I've sent my email information to Linda. Please reach out to me. The other thing that we need to make sure is any new legislation needs to include a statute of limitations that extends even the misdemeanors and the felonies to 4 years from discovery. That language is in the ICA. It's at section 22445, subsection D. And basically what it says is, hey, look, we don't expect our civilian victims to understand when they've been defrauded legally, especially when it takes 6 years to get through the legal system, right? So what the ICA does, and what multiple fraud, this is not unusual, this is kind of consistent through fraud statutory language, is it extends the statute of limitations for both the misdemeanor and a felony to 4 years, and the clock starts when the fraud is discovered, not when it occurs. So Mr. Smith goes in to get immigration, assistance in 2015, and it's not until in 2019 when he finally gets a letter saying he's been put in deportation, and he finds out that immigration consultant didn't do what he said he was going to do. That statute runs in 2019. Otherwise, he's out of luck. And so it's very important that we protect those statute of limitations and extend them from discovery and for a 4-year period so that the fraud, when it's discovered, can be handled. Otherwise, we're going to lose. Otherwise, these people become disenfranchised even worse than they were. In fact, they're worse off than they were prior to getting the legal help. We need to make sure that there's training aspects of this. You cannot ask a 21-year-old police officer to interview someone and know what their family law paraprofessional or immigration lawyer did wrong, because to them it all sounds like civil law. Okay, to a lot of lawyers it all sounds like civil law. So we need to make sure that there is some level, I'm not sure that this has to be legislated, but it's something that I feel the working group should really consider, into training law enforcement, judiciary, prosecutors, anyone who are going to come into contact with these, the small percentage that are going to be victimized here, with what they should be looking for. Okay, because we can't ask people to be experts in every practice that is being allowed to be paraprofessional, that the paraprofessionals are being allowed to work within. And then, of course, something that you all agree with, so I don't even really have to pitch it hard, but education. Just education about where to find out whether or not the paraprofessional they are hiring is legally licensed, has, any complaints against them. The questions of whether or not this stuff should be public, I think is very important, because light shines in the darkness, and it really does make a difference if they can easily find out if their person is on the up and up. And then finally, a restitution fund. Our victims, as I said, $5 million in damages just from the victims I know about. And these are victims who have saved this cash for years, and their families are now being faced with deportation, loss of their homes, loss of their children's health care. I mean, the effect on these families is devastating, far more financially, far more sometimes than our violent crime victims, because there is a violent crime restitution fund. So we need to, just as a general practice, but since we are trying to make this process as good as possible, a restitution fund fine for those who are defrauded by people being licensed by the board, by the state bar, or is really important, because they don't get this money back. That $5 million, I have restitution orders for it. They can all get civil, orders for it, but they're never going to see a dime of it. And they are also in a position of having to find a lawyer to go after that person. So that's, those are the things that I have seen while prosecuting this. Those are my concerns. I think it's important to understand that, well, the DA will prosecute it, unfortunately, is not as simple as that, and is quite resource heavy. All of this is quite resource heavy. And so when you guys are writing the statutes and writing how this will happen, if you build in the protections ahead of time, it makes it much more protective of the worst case scenario victims. And there will be worst case scenario victims. Luckily, it won't be most of them, but the 100 that I will, the 100 per case that I realistically get on these, it's a lot of people. And so I would just ask you to consider these things when deciding how you're going to proceed. Thank you.
Thank you, Ryan and Gus and Steve. Members of the subcommittee, any questions for our guests? I do also want to know, we did have a hand raised at one point by an attendee. So members of
I'm sorry, I did not see that.
No, that's okay. But members of the subcommittee want to hear allow attendees to ask questions or make comments, we can do that as well.
I have a question. This is Brady Dewar. I'm an assistant general counsel with the State Bar, and I've been working with this working group. And I think maybe this question's best for Ryan. My understanding is, as we've looked at this program, which would involve potentially allowing licensed paraprofessionals to do some things that are currently considered the practice of law, that technically that would fit right into our current UPL system, because basically it would be those people, if they have the license, would not be guilty of UPL because they're licensed, right? And if somebody was not a licensee and pretended to be, they would be guilty of UPL under the existing statutes, because they would not have a license and they'd be practicing law. So I guess I have two questions. One is, do you generally agree with that? And then, assuming the answer is yes, it sounds like what you're saying is, because this could, incentivize more people to commit fraud, it's a good time to look at sort of the existing resource problems with the UPL system before we make more changes. Is
I guess
fair?
so. Let's start with your first one. No, I actually don't agree that the people who are committing UPL now are going to go out and get licensed. They're committing a crime. They know for the majority of them, they know they're committing a crime or they're doing something illegal. And I don't necessarily think that they're going to decide that they're going to jump through any hoops that we're creating if they're already doing that.
I wasn't. I guess what I was saying is that.
Okay, I'm sorry, I misunderstood.
That it's creating a new category of behavior that is not UPL. Not that the people who are currently committing fraud are going to go out and get a license. What I'm saying is it's just sort of shrinking the category of what we treat as UPL, because the people who have licenses for this new kind of license are doing things that previously only a lawyer could do. Now they're permitted to do it.
Yeah, and I mean, I think that's absolutely true. We're just increasing the licensee pool.
Right. Right. Yeah. So technically, you under the existing statutes and the existing process, if you're unlicensed and you practice law, mm-hmm. the same process would still apply. But what I'm hearing from you is that that the resources there might not be sufficient, and maybe we need to look at our tools as part of this process.
I think that's it. I think we know these problems exist. They have not been addressed.
Yeah.
Yet, as far with our unlicensed practice of law section of the Penal Code. So if we are going to increase that pool of licensees, we need to make sure that we fix the mistakes that what I see as a mistake. I should make that clear. And I'm speaking from my experience, not necessarily as, our administration's position on this, but from my experience prosecuting these, that fixing those issues could really go a far way towards protecting people as we increase this pool. Because again, a percentage of that pool is going to do bad things, okay? And so we need to protect from that. But in addition, most people, we are opening that. I mean, my understanding is this is to extend legal assistance to a greater group of people, some of whom are less sophisticated, perhaps, are less able to get legal services elsewhere, and so this community is already searching for better answers. And my concern is they might know to ask, oh, are you a lawyer? And if the person says, no, I'm not a lawyer, to understand that they might have limitations because they're not a lawyer, or that they might have less limitations if they say, yes, I am a lawyer. But we're going to say to them, you don't need a lawyer for this. You need a paraprofessional. And that's fine. Like, I don't have issues with that, but we need to make sure that the law protects them equally if they hire someone who's a paraprofessional as it does if they hire a lawyer. And right now, at least on the unlicensed, unlawful. So let me explain. The unlawful part is they let their license lapse, or they are disbarred, or they are suspended, right? They're still a paraprofessional. That unlawful part, their license, they lose their license because they commit malpractice, they're prosecuted. If they're prosecuted a second time, it doesn't matter, it's not going to change. So we're giving them a break that we wouldn't be giving licensed attorneys, you know? Because if you're a licensed attorney, you lose your license and you practice law, you can go to state prison, you know, depending on the circumstances. So treating these paraprofessionals with the same level of responsibilities that they are taking on to provide services, they should also have the same penalties, in my mind, for doing it the wrong way. Does that make sense?
Yeah, and it sounds like maybe while we're at it, you're suggesting that same penalty be applied to repeat offenders who weren't licensed at all, whether it's an attorney, a paraprofessional, or at all.
Absolutely. That it doesn't really matter to the victim,
Yeah,
what the person's title is, you know, or you know what theory it is underneath them. They're still going to be victimized. And if we are going to say to them, we're licensing these people, they are trustworthy, and then they fail to follow through with the licensing, why shouldn't we treat them the same as we would? And why shouldn't we be protecting our victims the same as we would with licensed attorneys?
So Sharon, I see you have your hand up.
Thank you so much, Ryan. I have a question. I'm trying to get a better sense of when a case is within the jurisdiction of the state bar versus your office, and what happens to the non-immigration related fraud and UPL. Where do those cases go?
Okay, so the first question is, the jurisdiction shifts to us if and when it is presented to us as a criminal case. So we have jurisdiction over all felonies in LA County. So anything that's felony level. That's the other problem with the UPL, is a lot of these cases will happen and I don't have jurisdiction over them because they are in a city that has a city's attorney, though LA City attorney is very responsive to these. I don't want to disparage them at all. But the other issue is that LA County is huge, as we all know. And so I can't handle misdemeanors across the county. And it's 500 square miles. That's just not reasonable. So I can only really focus on the most egregious actors. So, you know, that's a resource issue. But pretty much what happens is Augustine's team will send me all of these UPLs. I will look at them, and maybe 1 or 2 a year we'll be able to investigate further, just because of the resource allocation and the fact that if the person is not a unlicensed lawyer, we can't get more than a misdemeanor on them. And so we have to use those resources wisely. The second, remind me what the second question was, Sharon. Sorry, I lost it.
Oh, what happens to the non-immigration related fraud and UPL cases?
So for the most part, if they are very serious, I do them. I mean, they're outside theoretically my you know, what I'm supposed to be doing in my unit. But I have 2 of those that I have looked at. We also have a unit that does judicial JSID, and they basically, anyone who's part of the judicial system and who does fraud, they will also take them on. But it's very rare. And again, it's a resource issue. We just don't have the bodies to do what is already out there. And again, that's not the state bar's issue. You know, that's LA County's issue. But it's something that when the state bar is, you know, when the committee is saying, well, the prosecution, the DAs can prosecute them, and that's our next level of discipline, it's absolutely true, but you should know what that level of discipline limits are going to be. And they're going to be, you know, they're going to be somewhat significant. I have a new administration. Maybe they won't be, because there is definitely a focus on more of this. I'm hoping for a focus more on fraud, but even if it isn't, 3 lawyers over 500 square miles with thousands of cases, it's just not a reasonable thing. We are not as, we don't have the same kind of manpower, person power for UPL that, for example, the state bar does.
And what happens to the cases that are fraud, but maybe are not egregious enough? And you said that you don't have enough resources. What happens to those cases?
They're rejected. If they're never brought, if there's no law enforcement officer or resource to investigate it, we don't even reject it. I put it away. And if so what happens is I'll put it away. And then when I get in new complaints, I run them to see if I have multiple complaints. If I start to get a large number of complaints about one person, then we start focusing on them. But if this person only gets a couple complaints, that case is just going to die. And that victim's not going to get any assistance, be able to get any assistance from us, unfortunately.
Okay,
Thank you.
Ira and then Kim.
Yeah. I have just one question. What is the which statute says that for lawyers who commit more than one, I guess it would be unauthorized practice of law, it's a felony, or it could be a felony?
None. Oh, lawyers? I'm sorry. I apologize, Ira. Lawyers is subsection B of 6126 of the Penal Code.
Isn't that the Business Professions Code? Or
I'm
no?
sorry, Business Professions Code. I keep saying that.
Okay.
I use the Penal Code a lot more.
All right, thank you.
And I'm not sure that actually says for subsequent convictions.
No, it's not for subsequent. It's what we call a wobbler, which means that it can be
Oh, any
either a misdemeanor or a felony. Yes,
even the first.
correct.
I think where you're seeing some other language that may contemplate subsequent convictions.
In the
Is for-
Immigration Consultants Act is the other language, Augustine. Sorry.
Yeah, and also in the Business and Professions Code 6126, it also states that a second conviction shall result in at least 90 days in county jail. And that's probably governed by the initial, up to 1 year in jail. But it says at least 90 days in county jail. But then here's the kicker that should probably be eliminated if they're revising the statute. It says, except in an unusual case where the interest of justice would be served by a lesser sentence or fine. So you're not going to see anybody do 90 days.
Well, why do you say that?
Because so the statute is set up that that the judges have discretion, and Augustine and I have our opinions of how these things get sentenced. They're not taken seriously. They're just not. Most fraud is not in the criminal justice system generally, but especially in times where the county jail systems are overloaded, they're going to be taken even less seriously. Again, it's a resource management thing. And unless we show by saying that it's a felony that it is important, it becomes less important, especially the first time. They're going to, a judge is not going to send someone who doesn't have a record just based on 22 years of experience into custody for taking money from someone. The problem isn't that first time necessarily. The problem is the 18th time, okay? Like the gentleman I'm dealing with now, who, if I can't find a felony filing, another theory of felony cases on him, all I can do is get him up to a year. And he won't do that year. I mean, the realities of credits in the county jail is he'll do a week or two.
Well, the sentence can also be payment of money and restitution. I mean,
Correct.
both.
And when they don't do that, then they're sent to county jail, but that doesn't happen.
And that assumes it's a willful violation of probation for failure to pay. Ryan would have to establish that they had the money and essentially
Mhm.
refuse to pay, because you can't send them to jail just because they owe a debt. So it's the
Right.
willful failure to pay as a result that's the problem. If I can just add, I spent 20 years as a criminal prosecutor before I came to the state bar, and what Ryan is saying is absolutely true. It very much is a resource issue. The state bar has advocated for resources for district attorneys' offices and law enforcement agencies to investigate and prosecute these types of crimes for this very reason. These crimes are very different than the other crimes that DA's offices generally deal with, because at that point they get a completed report of a bank robbery. And got an interview with all the witnesses by law enforcement officers that at preliminary hearing they can bring in, and through Penal Code Section 872B, they can have somebody testify as to hearsay and things like that. Those are things that we as the state bar, the investigating agency, cannot turn over to them for all the reasons that Ryan and Gus just mentioned about. We don't have sworn law enforcement officers. We don't have surreptitious recording. We don't have undercover capabilities. All of those things that they would then need to go back and reinvestigate or investigate for the first time in order to establish the criminal acts, as opposed to what Gus was talking about, which are utilizing the state bar's tools. So it's a very different type of thing that we can't necessarily help them with, and they don't have the resources, unfortunately, to do themselves.
The police and the sheriffs don't, do they have jurisdiction to do an investigation? But do they do them?
They can. Again, you're asking a 21-year-old police officer who rolls up on a call to understand that this paraprofessional's license is not good, and then recognize that as a crime and then arrest them. It's not, the training has to be there to do that. And how do they know that this paraprofessional is good and this one isn't, or that they can do family law, but they shouldn't be doing immigration law? That's something we're struggling with, much more, some officers trying to do his or her best, but doesn't have this background. So we have to understand the realities of this. Yes, sheriffs could do it, but they're about, again, resources. Again, law enforcement is shrinking, not growing. So, for whatever that is, we don't control what we can get our sheriffs to do. And, it's up to them whether or not they take these things on, and we can request it, but it's not going to happen on the majority of these cases.
Okay, Kim.
Just had a question for Mr. Hernandez. I was wondering how successful your cease and desist program actually is, and do most individuals just ignore those letters, and then you take most of them to the next step?
Well, as you might imagine, the success or the results run the spectrum of what could possibly happen. Some are returned, they have moved by the post office, so they never received the notice. Others, quite frankly, it's a piece of paper, they're gonna rip it up and throw it away because the strength of the teeth that it has is not necessarily there, since we're not law enforcement, Others, like I said, do take to heart what we said and actually have thanked us because they didn't realize that they were exceeding the scope of what they were allowed to do. We also have some where we have filed an assumption over their law practice, unlawful law practice, who have previously received cease and desist notices. So, the success of it is all over the place. All we can do is take the complaints in as they come and react to them. When we send a subsequent or a second cease and desist notice, we evaluate that very carefully. We don't want to just keep sending these letters to people and they're not obeying it. But sometimes our hands are tied. I remember I went on one case where we had sent out a few cease and desist letters to an office building. There was a fake address. The address was there, But I went, I spoke with the security at the lobby, and they said, we get people coming in here all the time for they're not here. They never were. They're probably operating offshore somewhere. So those cease and desist notices are sitting there in the lobby of that building. We had another one down the street from us just recently that we visited, and the suite number for that tower was actually the number designated for their break room. So they just make up things, and who knows how many of these cease and desist notices even end up anywhere or with their intended recipient. But I can't give you a breakdown of the success or how many people took to heart what we said and how many people ignored it or whether it was even received. But it's something we can't do when we don't have the resources for an assumption, because it's just not going to be there. It does have, like I said, also the added benefit of State Bar publishing on their website the name, all of the names associated with the recipients of the cease and desist notice and the city, so that the consumer that wants to protect themselves can go to our website and see, oh, okay, well, this person I better just stay away from. So
Kim, I'm sorry, Kim, go ahead. I was just going to piggyback, but I apologize for interrupting you.
Oh, no, go ahead. Go ahead.
I was just going to say, right now we have one person who is on probation for UPL, who has been practicing for 20 some years, who has had their practice assumed by the State Bar at least once, maybe a couple times, and is now practicing again under all of these things. The cynic in me believes it's because they believe that they can't get in more trouble than they already are because it's going to be a misdemeanor. So it might work for some, definitely. But there's definitely those who don't take it to heart.
And then my other question was just, has there ever been any consideration for hiring peace officers as your investigators, or is that just more of an issue for expense?
For the State Bar?
Yeah.
To my knowledge, we're not authorized to have peace officers. We don't have people who, can drive in cars that are cold-plated, that can carry weapons, that can interview people, that can surreptitious record. We don't have any of those powers statutorily. So
That
But
has
yes,
been pursued. Yeah, it has been pursued unsuccessfully. I see Ira has his hand up. I do want to do a quick time check. Linda, did we also today want to put the kind of chart back up and tackle some of the remaining issues with the structure?
There were the issues with the structure, and we still haven't to talk about the question of disciplinary records, what will be subject to public disclosure and for how long. So that's
okay. All right. So Ira,
we do have someone from the public, and we did sort of close public comment very early, and I know some people have joined beforehand. So if we want to allow for that, then we might want to do that.
Yes. Ira, why don't you go ahead, and then unless members of the subcommittee object, I would like to hear from the public member after Ira. Is that anybody object? The subcommittee? I don't see anybody's head objecting. Okay, go ahead, Ira.
Okay, my one question this time is, I'm looking at 6126 business profession, and it looks like it could cover the paraprofessionals because it talks about licensees of the State Bar, not lawyers, not members, licensees of the State Bar. And I'm wondering, maybe you can't answer now, but I'm wondering if you think that statute would cover the paraprofessional. It looks to me like it would, at least.
I think I could argue it, but I think we are much better off making it clear as there's no case law on it, right? That it's all new. So I think just indicating for the licensee aspect that it includes paraprofessionals is important. But the other issue of that is that people who hold themselves out to be paraprofessionals and are not are still only going to be misdemeanors. Doesn't solve that problem. And I'm not saying that's a problem you guys necessarily have to solve. You can kick it down the road, but it's, if they never get licensed, but they say they're a paraprofessional that was licensed by the state bar, they're safer than the people that you're licensing.
Because of the difference between A and B. Right?
Yeah. So if they never get their license, they will face far less criminal charges than if they get their license and lose it.
I think you are correct in that the statute may apply. I think, I don't have it in front of me, but it says those that are licensed to practice by the state bar or otherwise authorized by court rule or statute,
Correct.
which could encompass the
Correct. I mean,
profession.
this covers, and if we allowed this by court rule, somebody who was not a licensed paraprofessional and yet did practice law would be automatically guilty under 6126A, because it says any person advertising or holding himself or herself out as practicing or entitled to practice law or otherwise practicing law who is not an active licensee of the state bar or otherwise authorized pursuant to statute or court rule to practice law in the state is guilty of a misdemeanor.
So I'm not necessarily disputing that, although we may need to coordinate to make sure that other statutes line up, because Business and Professions Code 6003 talks about licensees of the state bar being divided into two categories, active and inactive. It doesn't envision, a different type of license, and so we need to ensure that all the statutes are consistent after whatever changes the working group recommends.
Mm-hmm.
Okay. From the attendee list, Angela Grijalva.
Hello, everyone. Can you hear me now?
Yes.
Awesome. Thank you all for being here. I'm a legal document assistant here in Sacramento, and I find it interesting, the enforcement issues. We're hearing these enforcement issues happening in Los Angeles County, where relatively there are a lot of resources. I neighbor Yolo County and other small rural counties where I can imagine resources would be even smaller or more limited. One of the things that I have done, I just so happen to be the president of the local chapter of the California Association of Legal Document Assistants. I make a concerted effort to reach out to these practitioners who are doing document preparation services and not bonded and registered. One of my issues when doing this outreach is verifying if they are bonded within the county. So luckily, Sacramento County does have, the clerk recorder does have an index that you can search and see if there's been a bond recorded, but it doesn't indicate the type of bond, if it's a notary bond or any other type of bond. So I say this because I think it would be helpful to educate the public. One, say, yes, you can now hire a professional practitioner, a paraprofessional to help you, but here's a centralized location, a database where you can verify their license and see if have been any pending reports, pending investigations, or we've had XYZ findings. And this is so the public can take that concerted effort to inform themselves prior to engaging this individual. That's one part. The other part I would like to share is in the demographic of public that I serve, it's divided for the most part into three separate categories. Clients who whose income is 100,000 plus, and they're simple transactions that they say, hey, the attorney told them, hey, you don't need a hired attorney, just go to the LDA and tell them to do this, which I get a lot of those clients. Then there's the middle income where the clients can afford to pay for my services, right? And then there's that lower income that y'all are referring to protecting, right? Those ones with limited resource, our immigrant community, so on and so forth, which fall into that demographic as well. Now, luckily here in Sacramento, we have a lot of not-for-profit organizations that I can send them to that they can get help at, right? And I volunteer at a lot. And I say, hey, if you can't afford me here, come and see me over here, and then I'll help you. But I only say this to further, I guess, explain the issue, because I hear us talking about only the vulnerable community members. And I think when we're talking about educating the public, I think we need to meet the public where they're at. One, these rural individual or in the rural communities where there's limited resources, there's no not-for-profits or very small not-for-profits that are inundated with need and demand, versus the larger counties, which may have a lot of resources, but are still, as you can hear, are strained. So I guess that's my public comment, is just, if you think about the public at large, think about it in the 3 income categories, right? And how we're going to approach each and every one of them, right? And make sure that the information is going to get to them where they are. Ideally, I follow Business Professional Code 6400, and I put my licensing and expiration date on my website and all of my advertisements. But I think that should be something else, the expiration date of the licensing, some kind of seal, yes, so it's an image recognizable that this person is licensed, or whatever the case may be. So thank you.
Thank you. Those are great comments. I do, I've kind of said this in various settings, but we'll encourage the working group to come up with some additional recommendations for LDAs, immigration consultants, as relevant to your work. But certainly the fact that there is no centralized place we can find everyone who is an LDA or a UDA is really problematic. And it's ancillary to what this working group is doing, but it would be really helpful for us to make a push to address that. Ira, did you have your hand raised again? I can't hear you. You're on mute, Ira. Oh no, okay, all right, great. So Linda.
I think it would be helpful to review this revised chart so that we can include it in the recommendation that's going to go to the working group for the 17th. And I don't know if we'll have time to do this, as well as discuss the issue of the status of discipline and how it will be, which categories will be public. But I would like to turn to this, if we can do that. I don't know if everyone had a chance to review it after it was posted. If there's any feedback on this?
So Linda, do you want to clarify where the decision points continue to be?
I actually think that this is the decision points that we had that were unresolved don't really appear in this chart. I think the idea was to propose the different options, and I think the only one, my understanding from the last meeting of this subcommittee is that the initial hearing would take place with a 3-person panel. I think that was the consensus of the subcommittee. And all that's left to resolve is whether the appeal would be to the licensing board or to another hearing panel. And I think that my understanding was that this subcommittee wanted to discuss that with the full working group rather than come to a determination in the subcommittee.
This is Justice Petru. Can I jump in and just ask a quick question? Because I'm a little confused looking at the chart. On the second to bottom line, the OCTC investigation / charging, if you go to violations identified and then go to the bottom line that says, yes, licensee does not dispute findings, it then goes to stipulated discipline. And I'm just a little confused. So when you say does not dispute findings, is the idea that there's a package presented that they would also be stipulating to the discipline, or is there a means by which one could say, yes, I did that, but not necessarily agree to the discipline that should be imposed? And if so, what happens then?
I think the idea was that the stipulated discipline would be if there's full agreement between the OCTC and the respondent. And if there's a disagreement, either with regard to whether they committed the violation or to the proposed discipline to be imposed, then it would proceed to either a hearing or settlement conference.
Then I would suggest some clarification to the chart, because then, for example, the line above the one I read should say, yes, licensee disputes findings and or discipline.
Okay.
And the line that I just read should say licensee does not dispute findings and discipline.
That makes sense, yes.
This is Kim. I was wondering kind of the same thing on the chart. And I was wondering if that was meant to go into that settlement conference box. So if they don't dispute the findings, then it's going to go to settlement where it has an outcome. Because you have 2 times where you could discuss settlement, it looks like on here, as part of it goes to hearing, and then it could go that way, or it could come out of the bottom one, but I'm not sure that they're different, if that makes sense.
I didn't quite understand what you were saying.
Okay, so I mean, I'm saying there's one where they don't dispute the findings, and then it comes up for stipulated settlement and then goes up to the paraprofessional board. And then there's the one that comes up through the process of they do dispute it and it comes up and it has a settlement. So I don't know why it's not, the settlement doesn't go into that same box if it's not disputed even at that point.
Do you mean
What's
the stipulated discipline, why it doesn't go to settlement conference?
What's the difference between the two? I guess kind of just to join on to Justice Petru, I don't know what the difference is between the bottom line and if it goes up, except for they don't dispute it at the first point. So I don't know who's going to be settling that because it's not really shown there. I guess the OCTC would be the one settling it rather than it going into that arbitrator. Is that correct?
Yeah. So it's the ideas you could avoid something having to go up to that level. And I think, I mean, Steve could speak to this, but if I recall correctly, there is the mandatory settlement conference now on the attorney discipline side. I think it's called something else, but I think the idea would be even when charges get filed, there is going to, so I'm not sure if it's an or if we're thinking every case where a charge gets filed, there will be a settlement conference as part of the disposition of the charge.
Thank you, Leah. That's correct. There is a mandatory early neutral evaluation conference that is part of the attorney discipline process. We are not convinced that the time spent preparing and trying to schedule those hearings are worth the outcome in terms of settlements that occur as a result of those settlements. Of those settlement conferences, what we're talking about, I think, at this point in the top blue line for stipulated discipline is an informal settlement process between OCTC and the respondent. And it is only if we cannot reach a settlement conference or settlement through that involuntary process that we would then go through the route of the notice of disciplinary charges. And then I would envision it as an optional settlement conference prior to hearing. If, for example, the two sides are nowhere near, then that's one thing. If you're looking at it as, there's a sticking point and maybe it would be beneficial to have a staff adjudicator's position on what the outcome should be that would help push one person, one side in the direction of the other, then maybe that would be worthwhile. But I would see that as coming before the hearing and not as an or to the hearing as is presented on the chart. Does that make sense?
This is Greg. I just have a question because I was confused also by the stipulated discipline box. Some of the cases we've seen, there's different types of stipulations. And Steve, maybe you can provide some clarity on this as well. But I've seen cases in which the respondent will stipulate to factual findings, but not conclusions of law or the level of discipline. Other cases in which they will stipulate to factual findings and conclusions of law, but they still dispute the level of discipline that OCTC wants to pursue. And those cases, it does, even though they haven't entered into a stipulation, and they actually get some mitigation credit for doing so if they are found culpable, it still results in a notice of disciplinary charges unless there's a full stipulation to all three categories. Is that right, Steve?
That's correct. That's correct. Excellent observation, Greg. Thank you. Yeah, the stipulated discipline really is it's like a plea to a prosecution's offer in criminal court, that where it really resolves all of the issues. So they plead to count one, count two will be dismissed, and here is the stipulated or agreed to sentence. That's what the stipulated discipline is here. Where there is some agreement where maybe they stipulate to facts and conclusions, but they don't agree to the discipline, we end up filing a notice of disciplinary charges along with submitting the stipulation, and then it narrows the issues that in this case, the state bar court needs to resolve, but in the paraprofessional one, whatever the three-person hearing panel would need to resolve, to just those issues in dispute.
So, Greg, I mean, if we have that definition of stipulated discipline in mind, so it's basically all three prongs that you referenced, I'm not thinking the chart needs to change, as long as that's the definition of stipulated discipline.
Yeah, I agree. I just want to provide that clarity because there are these other forms of stipulations that will result in notice of disciplinary charges. So I just wanted to, for people less familiar with this process, just make sure that there's some clarity around that.
Okay. And then, Linda, are you clear then on what change needs to be made in the settlement conference box?
Not complete. So can you see I've put up now the version that I'm working to revise. Can you see that now?
Yeah.
I've changed these two to say licensee stipulates to all findings and proposed discipline to this, that's the arrow leading to stipulated discipline. Is that accurate? And then the one above that, licensee disputes findings and or proposed discipline for notice of disciplinary charges. I took out the or in this connector. I'm not completely clear on what needs to happen other than that in the settlement conference box.
See, in the DCA world, can you remind us how the settlement conference is used?
Yeah, so it would actually really go to settlement conference first, which what I think that Stephen was saying. So you would go from notice of disciplinary charges into settlement conference usually first. And then if you can't, then from there it splits out. If you can reach a settlement at that point, then it'll go to the board. If you can't reach a settlement, then it goes to hearing.
So I would put a decision box between these two. So after the settlement conference, then it would, if a settlement agreement is not reached, it would go to a hearing. I can add that. Does that make sense?
But I think what Steve, you're saying, you don't think that process is particularly effective in the attorney discipline side.
It's not that I don't think it's effective, it's that I don't think it's necessary in all cases. And I would encourage this group to consider making it not a mandatory step. I don't think it necessarily makes sense to have it be for example, in the attorney discipline area, we cannot file a notice of disciplinary charges until we have had that ENEC process. And it just serves to delay many of our cases. And so in this sense, I think it makes more, in this situation, I think it makes more sense to allow us to file the notice of disciplinary charges and then determine if everybody wants to attend a settlement conference or not.
So to put it back the way I had it before with the arrow going in both directions, is this accurate?
Well, yes, except the settlement conference could then go back to a hearing, right? If there's no resolution at that settlement conference, it would then head back to the other box.
Right,
that make
that's
sense?
why I have the arrow going both ways. Does that work?
I think I understand it. We can do that offline.
Okay,
But I
great.
think the point is it's discretionary if the rest of the subcommittee, if the committee members agree to that. It's a discretionary settlement conference, and it sounds like it's the OCTC's discretion only. Is it OCTC or their respondent? Paraprofessional either can ask for a settlement conference.
Are you asking me?
Yeah, well, anybody, just to try to hone in on the issues.
I mean, I would hope we'd be able to say, yeah, that both sides would be able to agree that there would be some attempt at moving the case by having a settlement conference. My concern with having one party doing it is it could be used as a tool to delay, but I certainly understand that it may be beneficial.
I agree with Steve. I was in trials probably 15, 17 years. And I can tell you, I probably settled maybe 2 cases at the ENEC stage. They were just not productive. It was too early, or at least it was claimed by the other side it was too early. And it was misused as a delay tool. Going forward with this, with a paraprofessional structure that you're envisioning, you know what? If one side demands it, does the other side now have to comply? And does that serve the same purpose as it did before? Could it be a delay tactic? Or does, the other side, retain some type of a, I don't want to call it veto power, but something that both sides have to agree upon. Otherwise, it should not apply. The delay tactics will be removed. But if you allow one party to demand it, and it has to be done before a notice of disciplinary charges is filed, we're back to square one.
And Leah, I always want to clear up, ours are not really required. It depends on the length of the hearing. They always try to have an early settlement conference, like after the accusation is originally filed. And then if it's going to be a long hearing, I think it's 4 or 5 days, then the Office of Administrative Hearings, the ALJ, requires a mandatory settlement conference. So not all of them end up in a settlement conference, but there's always the option of settlement along the path until it gets to hearing.
Okay.
I wanted to make it, if I may, a distinction between whether a mandatory settlement conference should be mandatory and whether early neutral evaluation should be mandatory. If early neutral evaluation in the state bar system is similar to what it is in civil litigation, it's expensive. It takes a lot of work and time to do an early neutral evaluation as opposed to a settlement conference. And I think that certainly should be, both sides would have to agree. And if both sides have to agree, then it is a veto, and I think it's okay.
Okay. So given
I think
the,
Sharon wanted to.
sorry, I didn't see.
Sharon has her hand raised.
I realize that we don't have a lot of time, but I wanted to take advantage of the experts that we have on the phone right now, just to dive further into the current system and when something becomes a public record. But we may not have time to dive into that today.
And I think that we can leave the memo to say that that's going to be something that will be continued for consideration by this subcommittee.
Yeah, instead of making it a recommendation. And then for the next meeting of this group, we can ask OC. Steve is probably the resident expert on what is and isn't public on the attorney side and the rationale for same. So we'd probably invite Steve back, certainly, to talk about that with this group. Okay, so sorry we ran out of time, but we will get a draft out to you that hopefully reflects where you are. So an updated progress report to the working group, and teeing up that you really would like the working group to weigh in on the option 1, option 2 there. That's kind of the policy decision or process decision that you'd like them to focus on at the upcoming meeting. Does that work for folks? Okay.
Thank
Great.
you.
Thank you so much.
Thank you, everybody.
Everyone.
Thank you.
Mm.